Morning, Hearing Officer Lilly.
Good morning, Ms. Diaz. Thanks for reporting in. All right. I think everybody, well, it looks like there's one connection that's still happening here. I'll wait just a moment. And while I'm doing that, I believe, Mr. Serrano, you are 909-596-4733. Could you go off mute and just confirm that?
Yeah.
Okay.
Yes.
And I take it you're participating just by audio today?
Yes.
Okay. So we will be later on this morning asking you to put on your exhibits, but you can do that by audio only.
Yeah.
So, all right. It looks like everybody has connected. So good morning. My name is Alan Lilly. I'm the presiding hearing officer of the State Water Resources Control Board's Administrative Hearings Office. It is January 14, 2022, and this is the fifth day of our hearing on the prosecution team's draft cease and desist order against BlueTriton Brands, Inc. And I'm not going to ask for appearances. You all appear on the Zoom screen, and you've all entered your appearances before. So I'm going to cover a few things. I do not think we will end up taking all day today, but there are several matters I would like to cover before we complete our work today. And as I mentioned, we will also a little later on, after we get through the preliminary matters, proceed with the cases for Mr. Bilecki and Mr. Serrano. So first of all, regarding the motion in limine that Ms. Grady stated orally yesterday at the end of the hearing day, and then followed up with a letter, which I received, and it does appear she sent copies to everyone on the service list. And then this morning, I received a response letter from Ms. Doty, and then I received response emails from Mr. Lowe and Ms. Fry. And actually, just in case you're wondering why it took us 4 minutes longer than normal to log on, it was because I was printing the email from Mr. Lowe, which came in at 8:47 this morning, and wanted to read that, which I have now done. So I do have those papers, those 4 papers. I think all the positions are stated very clearly, and I'm prepared to rule. Oh, I did have one question for you, Mr. Silver. We received an email from you that appeared to just forward a copy of Miss Grady's letter. Was there anything else that you intended to submit to my office today?
No, it was inadvertent. I pushed the wrong button.
I think we all have done that before, so don't worry at all about that. I just wanted to make sure we didn't miss anything we were supposed to receive from you. Thank you for the clarification. All right, so with that, I am prepared to rule on the motion. I will give people opportunities if they have anything new. You do not need to repeat anything that is stated in your written submissions. Frankly, they're all very clear to me, and I've read them and considered them. But before I rule, does anybody have anything they want to add in the way of comments regarding the motion in limine? If so, raise your hand, please, either electronically or physically. All right, hearing none, I will proceed for my ruling. So just by way of introduction, yesterday afternoon, Ms. Grady did make an oral motion in limine on behalf of BlueTriton and then followed that with a letter that she filed about approximately 6 p.m. yesterday. This morning, I received an opposition letter from Ms. Doty and opposition emails from Ms. Fry and Mr. Lowe. And I have read and considered all of these documents. So just by way of background, in this motion, BlueTriton moves to exclude the evidence and testimony that provide information and documents that were not provided to the Division of Water Rights Enforcement Section before it issued its report of investigation and draft cease and desist order in April of 2021. My ruling is as follows. I deny this motion for the following reasons. First, Government Code Section 11513, subdivision C, provides that, quote, any relevant evidence shall be admitted if it is the sort of evidence on which responsible persons are accustomed to rely in the conduct of serious affairs, regardless of the existence of any common law or statutory rule which might make improper the admission of the evidence over objection in civil actions, end quote. BlueTriton argues that, quote, the new information, documents, testimony, and arguments that the participants now seek to admit into this action were not in front of the Enforcement Division. And in my written ruling, I do have a SIC here because it's actually the enforcement section of the Division of Water Rights when it issued the 2021 ROI and draft CDO, close quote. And for this reason, that such information is not relevant and should not be admitted into evidence. I disagree. Government Code Section 11513, subdivision C, applies to evidence parties offered during this AHO hearing, not to the process the Division of Water Rights Enforcement Section followed to develop the 2021 ROI and draft CDO. Under this statute, any evidence that is relevant to the hearing issues specified in the AHO's November 17 hearing notice may be admitted into evidence in this hearing, parentheses, subject, of course, to compliance with all other applicable rules of evidence, close parentheses, regardless of whether or not such evidence ever was presented to the Division of Water Rights Enforcement Section. 2, BlueTriton next argues that Government Code Section 11507, quote, should be considered for guidance here, close quote. That statute governs amended agency accusations in formal hearings subject to Division 3, Part 1, Chapter 5 of the Government Code. And that chapter is in sections 11500 through 11530. However, except for section 11513, none of the other statutes in this chapter 5 apply to this hearing. Section 11507 therefore does not apply to this hearing. The applicable statutes and regulations that do apply to this hearing provide our guidance for this hearing. 3, BlueTriton argues that if the AHO allows other parties to provide information that is new or different from that in the 2021 ROI and draft CDO, then such information, quote, would allow public participants to act as private attorneys general, close quote. I disagree. The 2021 ROI and draft CDO provided the, quote, statement of facts and information that would tend to show the proscribed action, close quote, as required by Water Code Section 1834, subdivision A. After the Division of Water Rights Enforcement Section provided this statement of facts and information to BlueTriton, BlueTriton exercised its right to request a hearing under subdivision B of Section 1834. When BlueTriton requested a hearing, the matter was assigned by operation of law under Water Code Section 1112, subdivision A2, to the AHO. The AHO then issued its July 8 hearing notice and its November 17 subsequent hearing notice. The AHO's November 17 hearing notice, not the 2021 ROI or draft CDO, defines the issues for this hearing. The AHO's November 17 notice satisfied the requirements of Government Code Section 11425.10, subdivision A1, which required the AHO to give BlueTriton notice and an opportunity to be heard, including the opportunity to present and rebut evidence. Under this process, other parties, as participants in this hearing, may submit any testimony and exhibits that are relevant to the hearing issues and admissible under the applicable rules of evidence. 4, BlueTriton next argues that allowing other parties to submit evidence that they did not submit to the Division of Water Rights Enforcement Section before it issued its April 2021 ROI and draft CDO would be contrary to Government Code Section 11425.10, subdivision A4, which requires that an agency's adjudicative function be separated from the agency's investigative, prosecutorial, and advocacy functions, and that this would disregard, close quote, the division of responsibilities that were the purpose of creation of the AHO as defined in Water Code Section 1110. BlueTriton goes on to argue that allowing parties to submit new information would convert this proceeding from a proceeding on the prosecution team's charging documents to a continuation of the prosecution team's investigation. I disagree. My allowing other parties to submit evidence regarding the hearing issues specified in the November 17 hearing notice allows these parties to participate in this hearing on the specified hearing issues. It does not extend the prosecution team's investigation process, and it does not affect or undermine the separation of functions between the hearing team and the prosecution team. In summary, allowing other parties to submit testimony and evidence that is relevant to the hearing issues specified in the AHO's November 17 hearing notice, regardless of whether they ever submitted the information in such testimony and evidence to the Division of Water Rights Enforcement Section, is appropriate and does not violate any of BlueTriton's due process or other rights. I therefore deny BlueTriton's motion. And this is a pretty clean draft, but I will clean this up and prepare a written order that basically states this and add that to the hearing record. I did want to make sure that everybody knew my ruling though today before we proceeded. So with that, I'm next going to go to the exhibits that BlueTriton offered into evidence yesterday. Let me just grab my file here, excuse me. Sorry, I have a lot of papers here. So the exhibits that were offered were BTB 1 through 5 and BTB 10 through 16. And just so our continuity is clear, I'm going to renew the opportunity for parties to object. I do want, Ms. Doty, I do want you to know I have read your response to BlueTriton's prior motion in limine, and in particular, your argument that you want the parties to be treated, you said equitably, I guess I would say equally or equally subject to the same rules. And I certainly intend to do that. Yesterday, you suggested that it would be appropriate for BlueTriton to stipulate to the admission of story of stuff exhibits. I don't think that's appropriate, and I'm not going to ask them to do that because you'll have an opportunity to offer your exhibits, and they may have other objections, but I can assure you that I will apply the same standards to your exhibits that I am applying to both the prosecution team and BlueTriton's exhibits. So with that, I guess I'll first turn to you. Do you still have any objections to these BlueTriton exhibits coming into evidence?
Thank you. I assume that the probative value that's applied to the individual exhibits and their attachment will be appropriately determined by, for example, the sourcing of the document, and obviously things such as the opinions regarding the law of BTB's counsel will be treated as opinions by BTB's counsel regarding the law. And with that assumption, we actually will withdraw our motion for equitable treatment. It was to raise the very issue that was addressed by your order today. So thank you.
Okay, and does that mean you're subject to that qualification, you're withdrawing your objection to these exhibits?
Correct, subject to that, I feel rather obvious qualification. So
Yeah, and I would, that's an important point, and I do want to clarify that BTB 3, 4, 5, 2, 3, 4, and 5 are all letters from Ms. McGuire, I believe. I know BTB 3, 4, and 5 are. I'm not sure of the exact format of BTB 2. I'd have to pull that up again. But the attorney letters, there's certainly nothing wrong with attorney writing letters. We do it all the time. But the attorney letter parts of those exhibits is hearsay. It's subject to use against BlueTriton under the admission by authorized agent exception to the hearsay rule. But there potentially are other statements in the attorney letters that may be statements of fact that are going to be subject to the hearsay rule. Hearsay rule, I should try again. The application of the hearsay rule in Government Code Section 11513 subdivision D. So they certainly will come in with that qualification. And of course, any party may raise that issue during their closing briefs. So with that, I'll first turn to Ms. McGuire, whose hand is up, and then I'll ask Mr. Petrozelli if he has any objections. So Ms. McGuire, go ahead.
Thank you, Mr. Lilly. Just a point of clarification, BTB 2, 3, 4, 13, and 14 were all submitted to the State Water Resources Control Board Division of Water Rights pursuant to their request as a part of the investigation of Nestle's, now BTB's, water rights.
Yes, and it certainly is appropriate for them to come into evidence. I don't think anybody is objecting to that. I think they are an important part of basically the history that led up to the draft CDO and 2021 ROI. I'm just saying that I think the parts of those documents that have statements from you, Ms. McGuire, are subject to the limitations on use of hearsay evidence that is stated in Government Code 11513 subdivision D. But subject to that limitation, they will be admitted unless anyone else has any objection. Mr. Petrozelli, I can't remember. Did you have any objection to any of these exhibits? If you can go, there you go.
Did not.
All right. And I don't see any objections from anyone else. So with that, they will be received into evidence. I do have a couple of other things I want to cover before we get to Mr. Bielecki's case in chief. I am planning to issue a notice. I wanted to give you all advance warning. The next 2 weeks are busy on my calendar, just too busy on my calendar, including both Monday being a state holiday. Can't have my staff work then, even if I work. And Tuesday and Wednesday, I have other state water board business. And the rest of the week, I just need to get caught up on things. And then the following week, the middle of the week is going to be occupied with our site visit. And I just really don't want to try to have hearing days during that same week. So I am targeting having the next hearing dates be January 31st, which is a Monday. And I will put this all in a notice, but we can go from 9 to 5 that day. The next day, February 1st, we can go in the afternoon, 1 to 5. The AHO has another matter in the morning, and my limited staff can only run one AHO proceeding at a time. February 2nd, we can go from 11 to 5. Again, we have a matter from 9 to 11 that morning. And then I don't think we'll need more days, but February 3rd, if necessary, we can go 9 to 5. My tentative schedule then is for written proposed rebuttal testimony and rebuttal exhibits to be due to be filed on February 14, and for the rebuttal hearing on rebuttal evidence to go from February 28 to March 4. So I just wanted to give you all advance warning. I know you all have busy calendars too, and we'll plan to go forward that way. And as I said before, my plan, I do respect BlueTriton's comment that it received a lot of exhibits from Story of Stuff and Amanda Fry. I'm not saying there's anything wrong with those exhibits, but just the volume is going to take some time for them to digest, and frankly, for me to digest. So that's why I'm going to delay the presentation of those cases until January 31st. And at that point, the order will be, we'll start first with Story of Stuff, and then we will proceed with Mr. Lowe and Ms. Fry. I think that'll be the most expeditious and least confusing, because Mr. Lowe and Ms. Fry are also designated as Story of Stuff witnesses. So I think we may be able to cover some of what they're going to say as part of the Story of Stuff presentation, and then as necessary, they can follow up with their own separate presentations. I do have, excuse me just a minute, I'm talking a lot this morning. I do have a couple of requests. First of all, Ms. Doty, for you, I would appreciate it, now that these exhibits have all been submitted to the AHO, if you could prepare a table of basically that lists the Story of Stuff exhibits, and then as appropriate, I know many of them are, and you said this yesterday, are the same documents as our prosecution team exhibits, and in some case, potentially parts of BlueTriton exhibits. So it would just really help me, and I think everyone else, if you and your staff could prepare a table. The easiest way is just list all the SOS exhibits, and then for the ones for which there's a corresponding PT or BTB or both exhibit, just list the number. What's a reasonable time frame for you to prepare that table and submit it to me, and of course, send it to everyone on the service list? And just a reminder, you probably need to go off mute. There we go.
I'm sorry, I have, of course, done that to some extent. It's a bit difficult because some of them are compilations. So I perhaps, could I have that to you in 2 weeks?
Well, let me check my calendar. Yeah, if you can get it to us by January 24th, okay? That gives it to us a week before we're going to start the hearing again. And I'm hoping it's a table, though you're right. Some of them, it's not just, you can't just list a PT exhibit and say it's the same, maybe part of it and so forth. So I realize there might be a little bit of work, but I think it'll really help all of us, including you. And it's certainly regarding admissibility of exhibits. If the same document already has been admitted as someone else's exhibit, you can still offer yours if you want to have it for your numbering system, but presumably people are not going to object if if a copy of the same document already has been admitted into evidence. So I think it'll help you too. And this is the other request. It's directed to Ms. Fry, although I see you are coordinating with Ms. Doty, so you may be able to prevail on her. That's up to you, of course, or up to her, of course. But I would like you to do the same thing. Prepare a table that lists all of your exhibits, just a table by exhibit number, Fry 1 through the end of the numbers. And then list when the same document is a PT, BlueTriton, or Story of Stuff exhibit. And again, that will help us. I think it'll really help move this process forward, because I think there may be a fair amount of overlap. And I would like you to do that and submit that by January 24th as well. That gives you 10 days. That really should help facilitate the process for all of us. So Ms. Fry, your hand is up.
I just had a question on the court cases. I originally scanned them, and then some of the copies weren't real good, so I asked the archive to rescan them, and that's what I submitted. So should I don't know. I mean, it's not exactly the same evidence, it is, but I tried to provide a better copy. Am I?
So fine. Then in your table, just put, for example, Fry 37, and then next to it put better copy of PTT 5.
Okay.
I'm just throwing out numbers, but
Sure.
yeah.
Mhm.
If it's not,
Okay.
if it's the same document, but a better copy, just say, refer to the other exhibit, put in parentheses, better copy.
Okay.
And yes, and we appreciate having better copies of those ancient documents. It makes
It's not
it for all
easy.
of us to read them. So
Okay.
no problem, but please just do that so we sort of know
Okay.
what we're
Okay.
all dealing with here. Okay, so that takes care of those things. For the service list, and again, I'm jumping around just a little bit. I have, sorry here, I've got a few papers. So Ms. Grady, you said that we hadn't updated our service list, and I apologize. I talked to Mr. Anderson this morning, and he told me that he thinks he now has. We added your email address, the email address of Ms. Slomsky, and then for Hee-Sung Kim, we did not have any mailing address, so we've just put his email address in the group with the Ellison and Snyder email address. Is that going to be acceptable?
Her email address.
Excuse me.
I will take a look. I believe Ms. Slomsky provided her email address in the original notice, but I will double check. And if there's a person I will ask her to resend it if there's any confusion. But
Yeah,
she
we
does
have
not
her email. We have her email address. We just don't have any mailing address.
Oh, mailing address. I apologize. I believe that should be fine. Yes.
Okay, so we'll just lump her with the other Ellison Snyder email addresses in the service list. And that way she, will get the emails, but we're not going to have any mailing address for her.
Thank you.
Okay, so we will do that. And then if any party has any further updates to the service list, please let us know. I mean, with email, it's pretty easy to add an email address or a couple of them. It's not a big burden. And if that helps people get notices, we certainly want to do that. Okay, so I'll tell you what, let's go ahead and proceed with Mr. Bielecki and then Mr. Serrano. And then if we have any further housekeeping matters, we'll cover them after we've done that. So if you have anything else, just make a note of it and we'll get to that. So I'm going to get Mr. Bielecki, my paper copies of Mr. Bielecki's exhibits, and then let's go ahead and get started with his case. Okay, Ms. Grady, your hand is up. Go ahead.
My only question, Mr. Lilly, is regarding Mr. Bielecki's scope of his testimony. My understanding for this proceeding is that we were instructed to provide summaries of our written testimony, and I did not receive any written testimony from Mr. Bielecki aside from the series of photographs with some notes on them. Can we have some instruction as to how this will proceed, please?
Yes. Again, with parties participating on their own behalf without attorneys representing them, I do allow some flexibility because the rules are complicated and they may not be familiar with them. I think, and Mr. Bielecki had some problems uploading exhibits. He ended up sending us a set of emails. I think we have 10, which we turned into exhibits that we labeled exhibits Bielecki 1 through Bielecki 10. They are mainly photographs with some descriptions, either in the subject line or next to the photo. I'm going to allow them, even if it doesn't rigorously follow the format that we asked for. I think Mr. Bielecki, frankly, did the best he could. He wants to get these photographs into evidence. I'm not sure whether or not they're going to be relevant to the hearing issues, although frankly, I think having pictures of the area could be useful. I think it does have at least some relevance. So I'm going to allow him to offer these exhibits into evidence, regardless of whether he followed the exact rules stated in the hearing notice. And Mr. Bielecki, frankly, your descriptions are pretty clear, and the photographs are pretty clear. So I don't need to have you read every single one. I think all we really need to have you do today is provide a summary, which basically says, here's what I did to prepare these exhibits. Here's the narratives. The narratives accurately describe the photographs, and go for and do that. So, Ms. Grady, that's what I plan to do. I'm going to allow him to do that. And then when it comes time to admit the exhibits into evidence, you may state objections if you have any. So, but before we get started, I don't want to forget. Mr. Bielecki, please raise your right hand. Do you swear? Right hand. Thank you. Do you swear that the testimony you will give during this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
All right. And Ms. Grady, your hand is up again. Go ahead.
Yes, I apologize, but respectfully, my question was asking about the scope of the testimony he'll be entitled to provide, because there was no written testimony provided. My questions did not relate to his photographs.
Okay. My view is that his labels of the photographs are his written testimony, and what's stated in the subject line. So I'm treating that as his written testimony.
Thank you for the clarification.
All right. So Mr. Bielecki, you've taken the oath. As I said, I've looked at exhibits Bielecki 1 through 10 as we have labeled them. I think the best thing would be for you to just provide a brief summary of what you did to take these photographs and prepare the captions and subject lines, and we'll go from there. But I don't think you need to read every single one. So please just do that if you can.
I'll make my best effort, Mr. Lilly. Thank you. And will I be allowed to provide any other oral summary here of the involvement of the Save Our Forest Association in this matter historically?
I really can't let you do that, because our rules did require you to submit written proposed testimony, and that would just be something totally different than what you have submitted. So I'm sorry, but I think in fairness to the other parties who I am holding to these same rules, I did state them pretty clearly during the pre-hearing conference. I am going to limit you to summarizing what is in these 10 exhibits.
Okay. So between the...
Could I object?
Excuse me, whose hand is up now? I don't see any hand.
I didn't get my hand up, but this is Steve Lowe, and I want to object.
What do you want to object to, Mr. Lowe?
Again, Hugh didn't understand, Mr. Bielecki didn't understand the rules that are written in the 48 pages of rules that we had. He did submit, I believe, Mr. Bielecki, you did submit a position statement, right?
Excuse me, Mr. Lowe.
Well, I'm sorry, but all I'm saying is, Mr. Bielecki has some real important stuff that's related directly to this whole process. He's been involved for 7 years now, and give him, in my opinion, please give him the chance to say what he wants to say. He's only probably going to take 5 minutes, 10 minutes. That's nothing compared. We've argued more than that over paperwork that may not even be important. This is so important. Please give him a chance to present what his case is. He'll do it in 10 minutes probably if you let him.
All right. So, Mr. Bielecki, have you submitted a policy statement separate from your photographs?
I submitted a statement previously within the time frame that outlined our organization's interest in this matter.
Okay, let's just take 2 minutes. Let me see if I can find your policy statement. And okay, I have a letter that you, Mr. Bielecki, submitted on May 2, 2016 to the Front Country Ranger District office. Let me see if there's anything else I have from you. Did you recall submitting anything else to this office other than that copy of that June 26th?
Yes, I recall submitting a document prior to I believe it was the December 17th deadline that essentially was the summary of my involvement, of our organization's involvement in this matter. So that would have been closer to December 2021.
Okay, I have a letter from you dated June 3rd, 2021. Is there something else besides that?
I believe
Lilly,
that's the document.
Excuse me, I think my staff is trying to help me out here. Please go ahead.
Look for a letter dated December 4th, 2021.
Okay, is that in the policy? What folder is that in, Mr. Anderson?
It's in the policy statements folder. The letter's dated 2021, 12/14, Hugh Bielecki email attachment letter. When you open the letter then is dated 02 May 2016.
Okay, just a minute. Mr. Anderson, thank you very much. I'm going to go in, and all of you can do this too. This is all posted on the AHO FTP page. Policy statements. We have a separate folder. And I see a whole bunch of emails here, Mr. Anderson. Which one is the one I should be looking at?
The Hugh Bielecki email attachment letter dated 2021, 12/14.
Okay, thank you. Okay, and that has a copy of the Save Our Forest Association May 2, 2016 letter. And then let me just check his other emails to see whether there's anything else here. Most of them, I think, are just attachments. So, Mr. Bielecki, we do have that letter you submitted to the forest in 2016. Is there, let me see what, I don't see anything else here yet with text in the policy statement folder. Did you submit something else that has text in it?
Yes, Mr. Lilly, I did submit a good cause statement. I believe it's titled.
Mr. Lilly, there is something called a good cause statement from August 5th that's in the pre-hearing conference statements folder.
Okay.
Yeah.
Just a minute. Let me get that. All right. I'm going to try to help out here. I also see a letter in the policy statement folder dated March 1, 2015 from Save Our Forest Association to the district ranger, which
those are documents that I've referred to also in what I was hoping to present this morning.
Okay, just a minute. Let me go through this. I think So, all right, so Mr. Anderson, you might take a look at that. There's just a document dated 2021-12-06 H. Bielecki email attachment. Doesn't say letter, but it says composite. And then I'm going to go back to it was the pre-hearing conference statements. Did somebody tell me? And what's the date of, oh, here we are. August 5, 2021, good cause statement. And that's a one-page document. So this is what I'm going to do. I'm going to take the policy statement that is dated, and Mr. Anderson, please take note and see if you can help me out here. We're just going to label these exhibits. They're not being admitted yet. But the policy statement dated June 3, 2021, we're going to label as Bielecki 11 and include that in the exhibits. So Mr. Anderson, if you can do that, that would be great. And then the email attachment that is the May 2, 2016 letter from Save Our Forest Association to the Front Country Ranger District Office, I'm going to label as Bielecki 12. And just a minute, the composite that was submitted on December 6th. You have to bear with me, my home printer is a little slow, but it appears to be a composite of 2 letters. Maybe 3. Okay, so then the composite, which has a letter dated March 1, 2015, to the Randy Moore Regional Forester, and also a letter dated February 8, 2018, to the State Water Resources Control Board. We will call those together Bielecki 13. And then the good cause statement, which was filed on, I believe, August 5th, which in the pre-hearing conference statements, we are going to label as Bielecki 14. So Mr. Anderson, can you find all those and make copies of them? Don't move them, but just make copies and put them in the exhibit folder, Mr. Bielecki.
I can. Can you just repeat what Bielecki 12 was again?
Yes, I rattled those off quickly. Bielecki 12 was the email attachment, one of them dated December 6th of 2021. And what it is a letter dated May 2, 2016 from Save Our Forest Association to the Front Country Ranger District Office.
Okay.
All right. So this is what I'm going to do then. We're going to, have you gotten those yet, Mr. Anderson? It's going to take you a few minutes to move them all.
It should take a couple minutes.
Okay. So everybody has access to the Mr. Bielecki's exhibit folder. And these will be in the files created by AHO. So this will be, we're going to add Bielecki 11, 12, 13, and 14 to that folder. And they're not super long. Each one's only a couple of pages. And then I'm going to give parties an opportunity to review those. And then I'm going to give Mr. Bielecki an opportunity to basically confirm that he sent those letters and if necessary, to provide a very brief summary of them as part of his testimony. And then we'll proceed with cross-examination and he can offer those exhibits into evidence and parties may object as they deem appropriate. And I do understand that this is a deviation from the precise rules for exhibits that are stated in my hearing notice, but consistent with the Water Board's policy of wanting to allow interested parties who are not represented by attorneys to have an opportunity to participate in these hearings, I'm going to allow this process to go forward for Mr. Bielecki, who frankly I think, is doing everything he can to try to submit documents in good faith for consideration in this hearing. So with that, we're going to take a break until 10:10, and hopefully the exhibits will be posted in the next few minutes, so you'll have a chance to review them, and then we will be back at 10:10. Thank you. And you don't need to log off. Oh wait, Ms. Grady, you do have your hand up. Go ahead before the break.
I have questions that I can bring up later, but at issue is I don't know what you identified as Bielecki 13.
Okay, yes, Bielecki, and of course we'll post this, which that's why I'm doing this, is so we can all get the documents. But Bielecki 13 was it was what's called the composite email attachment that Mr. Bielecki filed on December 6th of 2021. And what it contains is a March 1, 2015 letter to the Randy Moore Regional Forester, and also a February 8, 2018 letter from Save Our Forest Association to the State Water Resources Control Board. So, and that's why I'm giving this extra time, so that when they're posted, everyone will be able to look at them and we'll be able to see what we've got here. Okay, so with that, we're going to go on break. You don't need to log off, but you can turn off camera and microphone, and we'll be back at 10:10. Thank you. All right, everybody is coming back. We'll wait just a moment here. All right. We have uploaded or copied over the files that Mr. Bielecki previously filed with the AHO in this proceeding into the Bielecki exhibit folder and the subfolder of files created by AHO, and have labeled the documents I discussed before our break as Bielecki 11, 12, 13, and 14. So with that, Mr. Bielecki, if you can go off mute, I'm going to just ask you a couple of foundational questions that I think can get us through this process most efficiently. And then I'll give you an opportunity to provide a brief, an emphasis on brief summary of your testimony. So Ms. Grady, your hand is up. What is your question?
Yes. I seem to have some extreme echoing. Is it better now?
It's fine. I can hear you.
Okay. I do have to object on behalf of BlueTriton. It appears that this proceeding is kind of lost track. Mr. Bielecki, I appreciate difficulties with technical issues. We all have them. I've even had them today. But there was no indication that any of this information was provided as testimony. Mr. Bielecki is a professional. He's not an attorney, but he holds himself out as a professional trained dentist, I believe. Your instructions in November were clear to provide written testimony. And it's just, right now we have absolutely no indication of the scope of what's being presented in this parallel prosecution.
All right. I'm going to overrule objection for now. I'm going to exercise my discretion as hearing officer to proceed as I have indicated I'm going to proceed. I'm going to ask him my questions for foundational issues about these exhibits. When we have finished that and he has summarized them, you may renew your objections if you believe they still are appropriate. These documents are short, the new exhibits 11 through 14. I've given you an opportunity to read them. If the issue is you need more time to read them, you can let me know after I've completed the questioning I'm going to do now. But I do plan to proceed. As I said before, I am giving all parties, I'm exercising some flexibility for all parties so all parties will have opportunities to have their cases presented. And just I'll remind you, I certainly did allow BlueTriton and prosecution team and Ms. Doty all considerable additional time on cross-examination beyond the initial limits stated in the hearing notice. So I think I also may give Mr. Bielecki some flexibility as I deem appropriate. Certainly, at the end of the day, we will only consider evidence that is relevant to the hearing issues as we prepare our proposed order. So your objection is noted and overruled for now, but without prejudice for your right to raise that again as you deem appropriate after I've completed my questioning and Mr. Bielecki has completed his summary. So with that, Mr. Bielecki, do you have before you, are you aware of the photographs in your emails that we have labeled as exhibits Bielecki 1 through 4 and 5 through 10?
I do not have them in front of me on a monitor on a device. So I was, for any of those photographs 1 through 10 that we may look at this morning, I would rely on your office to put those on the screen, as was done briefly yesterday.
Okay, that's fine. So I'll ask the question a different way. Did you take the pictures, all of the pictures that were in the emails that were attached to the emails you sent to the hearing office and all the parties to this proceeding by email on December 16 and December 17, 2021.
So yes, I took all of the photographs that were submitted in Bielecki 1 through Bielecki 10, and those were taken at different time points between April 16th, 2021 and December 4th, 2021, in order to illustrate changes in the areas depicted in the photographs based on the time of the year.
Right. And in the various emails, sometimes in the subject line and sometimes in text next to the photographs, you have descriptions of the dates of the photos, the subject matter that is depicted in the photos. Are all of those descriptions and dates accurate?
To the best of my knowledge, yes. All of the dates are accurate and all of the descriptions are accurate and as brief as I could make them to provide some orientation as to what's being depicted in those photographs.
All right. And then the same question I have for the movie that is in what we've labeled as Bielecki 4. Did you take that movie?
Yes, I did take that movie on December 4th, 2021.
Okay. And the subject line says video of FS water right, Strawberry Creek, Headwater Spring, Rockwall. Is that an accurate description of that video?
That is correct. I was using the FS water right to describe the location of that photograph because the FS water right was listed as an identifying location on one of the maps that I've seen during these or prior to these proceedings.
All right. I'm going to move forward to Bielecki 11. If maybe it'd be good, Mr. Anderson, if you could put this up on the screen just so we're all clearly we all are on the same page, literally. So either Mr. Woldridge or Mr. Anderson, if you can put up Bielecki 11. Thank you, Mr. Woldridge. And just scroll slowly down this. Mr. Bielecki, can you see this on the screen?
Yes, I can.
And did you write this letter and send it to the State Water Resource Control Board Administrative Hearings Office on June 3rd, 2021?
I believe I did. If we were scrolling to the bottom of the letter, yes, I did write that letter.
All right, let's go on to Bielecki 12. Mr. Woldridge, please put up Bielecki 12.
Mr. Lilly, I believe that part of Bielecki 11 also included a May 2, 2016 letter to the Front Country District Ranger.
Yeah, hang on. We have labeled that as Bielecki 12. It's coming up now.
Okay. All right.
So we've posted Bielecki 12, which I believe is the letter you just referenced. Did you, in fact, sign this letter and send it to the address listed at the top of the letter on May 2, 2016? And we'll just scroll down so you can see your signature.
Yes, I did.
All right, let's go on to Bielecki 13. We'll post it here just a moment. So the first two pages of this are a letter dated March 1, 2015 to Randy Moore. Mr. Woldridge, please just scroll down so Mr. Bielecki can see his signature on that. And then if you can go down to the third page of this exhibit, this is a letter dated February 8, 2018 to the State Water Resources Control Board. And just go ahead and scroll down to the last page of that so Mr. Bielecki can see his signature. All right, Mr. Bielecki, did you in fact sign both of those letters and send them to the addresses listed on the dates indicated?
Yes, I did.
All right, let's go on to Bielecki 14. And this is a document at the top. It says good cause statement for Hugh Bielecki, DMD. And at the bottom, it says the date is August 4 of 2021. Did you, in fact, send this letter to the Administrative Hearings Office on August 4 of 2021?
Yes, I did.
All right. So, Mr. Bielecki, I'm going to treat these 14 exhibits as your exhibits and testimony for this hearing. You've already provided authentication and some brief summaries of the photographs. I'm going to give you 5 minutes maximum, if you don't need to take the whole amount, to add any more testimony you would like about these exhibits. I do want it to be in the form of facts about about your testimony and exhibits, if you can. I realize I'm sort of putting you on the spot. You don't need to say anything more. I think these all are now adequately authenticated, but is there anything more you would like to say about them? And Ms. Grady, I've said you may object at the end. Is there some reason why you need to object now?
I object on the grounds that this is beyond the scope of what was excluded based on my cursory review of these documents, that the hearing office just converted one from a policy statement to an exhibit, and the other ones, I'm still not quite sure where they came from, but I will reserve the rest.
All right. Why don't you, Mr. Bielecki, do you have any summary you want to give of these exhibits and what I'm treating as testimony?
Yes, I do.
Go ahead. But again, this is going to be 5 minutes maximum.
Okay. So the Bielecki 11 through Bielecki 14 that we have just reviewed indicates the interest that the Save Our Forests Association has made as early as March 2015 in the first letter to Regional Forester Randy Moore, Region 5, that reflected our attempt to meet with the SBNF Forest Supervisor, Nestle Waters of North America, the Sierra Club, and the Audubon Society, and we had received no answer to that initial request for a meeting in September 2014. I reiterated the request for a meeting with the Forest Service, Nestle, other agencies and groups as appropriate, and restated that request for a meeting in the March 2015 letter to Regional Forester Randy Moore. That was followed up with a letter in May 16th to the Front Country District Ranger acknowledging the April public scoping meeting, which I and many members of the public attended, and that proposed the 5-year NEPA study that is still going on today. And at that time, we had objected to continued water diversions and asked for those diversions to be stopped until there was a thorough review of all aspects surrounding the special use permit. In Bielecki 13, I specifically addressed the issue of illegally claimed Nestle water rights and referred to the complaints that were submitted, I believe, between April 2015 and September 2017, and specifically referred to the lack of recorded claims at the withdrawal sites T2N R3W in Strawberry Creek and T1N R4W in Indian Springs. In that letter, and I quote, we're of the opinion that no evidence-based proof of water rights translates to no water permitted removal. And that as the ROI states in section 6 recommendations, quote, division staff recommends that Nestle immediately cease any unauthorized diversions, unquote. So I believe we've laid a foundation for multiple attempts to communicate with the U.S. Forest Service regarding this previously long expired permit, and to specifically address the issue of claimed water rights in Strawberry Canyon. I I might note there was also, I believe, a letter that was sent, or a copy that was sent of the League of Women Voters in San Bernardino area press release that resulted from a January 29th, 2017 public meeting that was co-hosted by the League of Women Voters and the Save Our Forest Association at the Twin Peaks Community Center, in which the U.S. Forest Service and Nestle Waters of America were invited and declined to attend. We've made numerous efforts to attempt to understand and to attain documentation and conversation from the U.S. Forest Service and Nestle Waters of North America, and have been rebuffed on all of those attempts.
All right, does that conclude your summary of your testimony?
Yes.
All right, thank you. Does anybody want to ask Mr. Bielecki questions on cross-examination? Please raise your hand, preferably electronically. Okay. I am seeing no, oh, wait, Mr. Lowe, go ahead. You may ask your questions.
Yes. My question is to you, Mr. Lilly. We get 45 minutes for our case, correct? And 5 minutes for the opening statement?
Yeah, Mr. Lowe, let's go ahead and we'll handle this later when we get to additional process. Mr. Lowe, I'm going to cut you off now. Mr. Bielecki has put on his case. He has stated what he wants for his case, and he said he is done. If you want to say something further when it's your turn to put on your case, you may, but I don't want you basically commenting on how Mr. Bielecki puts on his case. I mean, I'm trying to give some leeway here to parties who do not have attorneys representing them, but I think I've got to have that control over the proceeding. So unless there's something really pressing that you need to add here, I'm going to ask you to not say anything more now. Is there something really pressing you would need to say now?
I don't want to upset you, but I wanted to say that Hugh and I actually talked this morning or yesterday morning about this. And I said, Hugh, you don't have to worry. It's not just 5 minutes. You get a 45 minutes to present your case. So why don't you and I both combine our opening and our case so that we don't exceed the 45 minutes and make it short? We could both do it short. And so that's what Hugh was going to do this morning, was combine it into his case. So now shutting him off at 5 minutes, I'm sorry, I can't see where that's right at all. I don't understand.
Right. So Mr. Lowe, that's enough.
Okay, thank you.
Thank you. I have given considerable leeway to Mr. Bielecki for not, even though he did not follow the rules for the hearing notice. So I think the way I've proceeded is appropriate. I think Mr. Bielecki gave a very clear summary of his exhibits and testimony. I certainly understand it very well. I don't see the need for more time. Mr. Bielecki has not asked for more time. And then Mr. Lowe, as far as your presentation of your case, that will come later. And of course, you may coordinate with Ms. Doty. So hearing no other requests for cross-examination, Mr. Bielecki, I assume you want to offer into evidence what we have labeled as exhibits 1 through 14. Is that correct?
Yes, I would.
All right. Are there any objections to Bielecki exhibits 1 through 14? All right, Ms. Grady, please state your objections.
With respect to the documents that the hearing officer just created as exhibits that were previously either identified as policy statements or not otherwise identified, and allowed testimony outside of the scope of the hearing officer's instructions in the notice of hearing, we object on those grounds procedurally. And with respect to the specifics of the documents, although we've had very little time to review what these were in anticipation of proceeding, it appears that the letters largely go beyond the scope of what the hearing officer has defined to be the issues presented.
All right. So I'm not hearing any objections to exhibits Bielecki 1 through 10, which were previously submitted and labeled by the AHO. So I'm going to admit, oh, excuse me, Miss, oh, your hand's not up. Okay.
I did have exhibits to 1 through 10 that I had submitted to you previously. My understanding, and for purposes of clarifying the record, I think you have overruled those objections regarding time, just to make sure that we've got these issues presented near each other in the record.
So do you have any objections to exhibits Bielecki 1 through 10, other than those, I'll call them timing issues, that you raised in the motion in limine you filed yesterday evening?
No.
All right. So, and obviously I denied that motion. So I'm going to admit exhibits Bielecki 1 through 10 into evidence. Now, regarding exhibits Bielecki 11, 12, 13, and 14, which admittedly we did just label, they had been in the record, although not as exhibits before. Ms. Grady, I'm first, I'd like some clarifications here. First of all, we have allowed other parties, including BlueTriton, to submit various exhibits that were letters that were sent to the Forest Service and other parties in the past that are relevant to the hearing or may be relevant to the hearing issues. So I don't think that in and of itself is grounds for objection. I did hear your objection on process grounds that you hadn't had a chance to review these before. And I gave you some time, admittedly limited. Now that you've heard Mr. Bielecki's summary of these exhibits and they're numbered, would you like more time to review them before and to make any additional specific objections you have to these 4 exhibits?
I would. I believe from my quick review that they contain a lot of information regarding public trust and policy, and I have to object and disagree with the representations of what BTB has been allowed to do. I mean, this is procedurally absolutely confusing as to what's happening right now.
All right. So this is what I'm going to do. I want to make sure that you have a fair hearing too, just the way I want to for all parties. So I'm hearing a couple of different things. Number one, to the extent that Bielecki 11, 12, 13, and 14 address public trust issues, or I think that that's one you just raised. I agree that they should not be admitted for that purpose simply because I've ruled that the hearing will not consider public trust issues. That was a ruling I issued back in November. So I think just as a practical matter, I can let them into evidence with the understanding that they may not be used to address issues that are beyond the hearing issues. And beyond that, I heard you state a concern that you hadn't had enough time to review these, and I think that's reasonable. And it's a good time for a morning break here. They're not super long, but I do understand you want to read them. So would you like to have another 25 minutes of break to review them? Again, with the understanding that even if I admit them, we're not going to allow them to be used for public trust issues that are beyond the scope of the hearing. But I think there is some information in them that is related to the hearing issues. So if you want more time to review them and state objections in more detail, I'll give it to you. If you don't, then we will proceed.
I think it would make sense to reserve on the opportunity to object, and for purposes of efficiency of this proceeding, maybe going forward, and we could circle back to whether those are admitted or any other specific objections detailed at a later time.
Okay, I don't want to just leave it open-ended. I want to get this resolved. So I'm going to take a 25-minute break until 11 o'clock to give you ample time to review them in as much detail as you want. And then you may state your objections, any additional objections. And again, I think I've my ruling should make it fairly clear as to what I'm allowing them for and what I'm not allowing them for. But we will do that. We'll come back at 11. I will rule on that. And then we are going to go forward with the case of Mr. Serrano. So we'll be on break until 11 o'clock. Thank you. All right. I'm back. We'll take the break sign off the screen and get started here. Just give one moment and see if Mr. Petrozelli wants to join us. Okay, well, I'm going to go ahead and get started. So, Ms. Grady, I gave you an additional 25 minutes to review what we've labeled as exhibits Bielecki 11 through 14. And would you now like to state any objections to those exhibits?
I would, thank you.
Please state your objections.
With respect to the exhibits identified this morning as Bielecki 11 through 14, with respect to all of them, we object on the basis that both your July 8th pre-hearing notice and your November 17th pre-hearing notice provided for participants to offer non-evidentiary policy statements. They also made clear in those notices, in particular the November 17th notice and in the pre-hearing conference that followed, that any evidence, oral evidence to be presented needed to be submitted in writing by December 17th, and that the parties would be allowed to provide summaries. This morning, the hearing officer placed these 4 documents, when these documents were submitted by Mr. Bielecki to the state board, it appears that the hearing office placed these documents that are at issue into the policy statement folder. And this morning, for the first time, the hearing officer independently identified and moved these 4 documents from the policy statement folder, identified them as exhibits for Mr. Bielecki, and moved them to the exhibit folder. The hearing officer then invited Mr. Bielecki to provide oral testimony regarding these documents, and it's testimony that was not provided in writing in advance of the hearing or by the December 17th deadline as required by the pre-hearing conference notices and instructions from the hearing officer in this proceeding. So that's with respect to all 4. With respect to Bielecki 12 and Bielecki 13, these are letters directed to the Forest Service that address public trust issues that are excluded by the November 4th, 2021 order of the hearing officer. And with respect to Bielecki 14, this document on its face appears to clearly and intentionally have been submitted as a policy statement.
Does that conclude your objection?
That concludes my objection.
All right. I overruled the objections. Regarding the overall process arguments, I have exercised my discretion as hearing officer to help Mr. Bielecki, an unrepresented party, submit testimony and exhibits for this hearing, even though he did not comply with all of the procedural requirements in the notice. I believe this exercise of discretion was appropriate and did not prejudice the rights of any party. Regarding the admissibility of these exhibits, I believe that they are admissible under Government Code Section 11513, Subdivision C. I will say, and regarding the question of whether or not these were previously submitted as policy statements or for other reasons, I believe that as part of my discretion in assisting an unrepresented party with the process, I am authorized to and have decided to in this matter treat them as testimony by written proposed testimony by Mr. Bielecki, which he has authenticated. At least parts of each document are relevant to the hearing issues. If there are parts that are not relevant to the hearing issues, I will not rely on those parts when I prepare the AHO's proposed order in this matter for transmittal to the board. So with that, I previously admitted exhibits Bielecki 1 through 10, and I now admit exhibits Bielecki 11 through 14. I will say, Ms. Grady, and I'm not sure how this would come up, but if in briefing you believe that either another party in their briefing or me in the draft proposed order have relied on irrelevant parts of these exhibits for the proposed order. Not quite sure exactly how I could do that, but if you thought I did, you certainly may raise that issue in objections to the draft proposed order, and I will be submitting a draft proposed order for review and comments by the parties before I prepare and submit the final proposed order to the State Water Board. So with that, I believe I did say, in case I didn't say it before, I believe in this case I do have discretion to treat documents that Mr. Bielecki may have previously submitted as policy statements as testimony, and I believe these documents do contain, at least parts of them contain appropriate testimony, even if there also are parts that are more appropriately treated as policy arguments. And I will certainly treat the different parts of documents appropriately when I'm preparing the proposed order. So with that, we are ready to move on to Mr. Serrano. Mr. Serrano, I believe you are still here by telephone, at least I hope. Yes, I do see you here by telephone. Are you there? Please go off mute if you can.
Yeah. Can you hear me now?
Yes, I can. So Mr.
Okay.
Serrano, you previously submitted for this hearing exhibits that you labeled as AAAS 1 through 6.
Yeah.
And that you had an email transmittal, which we have relabeled as Exhibit Serrano 7. So first of all, before we proceed, I'm going to ask you to raise your right hand, even though we can't see you, and tell me, do you swear that the testimony you will give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
All right. So I believe your email transmittal, which I've labeled, or my office has labeled as Exhibit Serrano 7, describes your other 6 exhibits and the purposes for which you are submitting them. So first of all, is the exhibit we've labeled as Serrano 7, in fact, does that contain accurate statements of what you would like to state for this hearing?
Yes.
All right. So I'm going to treat that as your written testimony, written proposed testimony, which you have now affirmed as your testimony for this hearing. Do you have any summary you would like to give of either that transmittal or any of the exhibits? And you don't have to, but if you would like to provide a brief summary, it does have to be limited to the matters that are stated in these documents. But if you would like to present a summary, you may.
Yes, I would like to make a short summary.
Please go ahead.
Yes, on exhibit number 1, there are 18 sections to an asset purchase agreement. And as you can see from exhibit number 2, which is my email response to Victor Vasquez, dated January 29, 2018, I specifically requested 3 items relating to asset purchase agreements having to do with contracts with Nestle and or Arrowhead, now BTB. And number 3 on that particular exhibit, which is the Supreme Court case, and you can see the citation from year 1855, which was, within 5 years after statehood for the state of California on September 9th, 1850. This case law, if you will, goes back to those years. And Exhibit 4, which is a 2014 article by the nonprofit Water Education, talks about appropriative water and also what the requirements are for posting. That article made reference back to the 1855 Supreme Court case. And in Exhibit 5 on the Water Code 5101, the statement of diversion requirements go back to December 31st, 1965, and are very clear. And the last item, Exhibit 6, which is the appropriated water streams, which goes back to November 16th, 1989 on an order WR 89-25, again, is very clear and specific. And my point is this, from a local resident standpoint in the city of Highland, it's pretty clear for those of us who have worked on water diversion projects in our community over the years, what we're required to follow in terms of the water code, the regulations, the water board requirements. And from all of the documents that I've read for the last 7 years and the testimony today is just simply outrageous to the local residents. We have 55,000 residents in the city of Highland. We're located next door to the San Manuel Indian Reservation. We have the Bunker Hill Basin, which is our groundwater, and all of these items were affected. So that's my testimony. Thank you.
All right, thank you, Mr. Serrano. Does anybody want to ask Mr. Serrano any cross-examination questions? Okay, I'm just double checking here. I don't see any electronic or real hands up, so there will be none. And Mr. Serrano, would you like to offer your exhibits 1 through 7 into evidence at this time?
Yes.
All right. Are there any objections to the admission of exhibits Serrano 1 through Serrano 7? Ms. Grady, please go ahead and state your objections.
Mr. Lilly, our objections to this were submitted in the motion in limine on which you deferred your ruling. And the objection was based on the fact that there is no proper foundation and these documents are either not the nature of what is evidence, case law aside. And for those reasons, we object.
All right. The objection is overruled. I think he has provided a foundation for exhibits 1 through 6 through his written test. What the document I have treated as written testimony is exhibit 7 and how he has summarized that today. And I believe these are documents that are admissible under Government Code Section 11513C. If during the course of arguments, questions come up regarding whether or not there's hearsay, certainly the parties have rights to raise those objections under Government Code 11513 subdivision D. At least, I think these exhibits are at least marginally and possibly somewhat relevant to the hearing issues. And therefore, I'm going to admit them. Of course, as I stated in connection with Mr. Bielecki's exhibits, if anyone believes that either someone else's brief or my draft proposed order relies on evidence in these exhibits that is not relevant, that party may raise that objection at this time. All right, so Ms. Grady, do you have another comment? You're on mute though, you have to, there we go.
Thank you. I do, and I apologize. I did not catch that you had identified the correspondence email as what I believe you might have just marked as an exhibit. For reference, what number would that be?
I'm sorry, you broke up. What are you talking about?
I believe I had missed, but I think you may have stated that you converted the corresponding email to an exhibit, and I'm asking what number?
Okay, no, that's not what I said. On December 17, Mr. Serrano submitted a transmittal memo to the AHO, which described exhibits. He has labeled them ASS1 through ASS6. My office labeled at that time, and we notified all the parties, and this is in Mr. Anderson's memo that was circulated a few weeks ago, or no, excuse me, was circulated on January 7. we just labeled that transmittal memorandum as Exhibit Serrano 7. And I'm treating that as his written proposed testimony. But that's all we did. So does that, with that clarification, do you have any further objections you want to raise now?
No.
All right. So for the reasons I just stated, we will admit Exhibit Serrano 1 through 7 into evidence. And with that, and thank you, Mr. Serrano, for your testimony. I realize it's a little bit of a challenge to participate by audio only, but we were able to hear you clearly. So thank you very much.
Okay.
And with that, I think I told you before, my plan is to reconvene on January 31st. There are various homework assignments. I'd asked Mr. Lawrence yesterday to prepare some documents, and I will follow up with a written list of those, a list in writing of those. And I asked Ms. Doty and Ms. Fry to prepare some tables of basically tables I'll call different labels for the same different exhibit labels for the same documents, which I asked them to submit to facilitate our process. So I think with that, I am agreeing to BlueTriton's request for more time to review the somewhat voluminous documents submitted by Story of Stuff Project and Ms. Fry, and also Mr. Lowe's documents. So I'm giving an additional time till January 31st for that review, and we will proceed then. And the order of proceeding, as I said before, will start with Story of Stuff's case. Of course, opening statement by Ms. Doty will be allowed. We'll proceed with witnesses, and then we'll proceed with Mr. Lowe and then Ms. Fry's separate presentations. So, and of course, we do have the site visit still set for January 26th to 27. I'm going to try to get that notice out. I don't know whether we'll be going to the San Manuel Tribe of Mission Indians land, depending on whether or not they grant permission, but we will plan to do the rest of that trip if we can. Of course, please make sure to check your emails frequently, because it doesn't look like there's any inclement weather on the horizon for those days, but we will postpone if there is. So Mr. Bilecki, your hand is up. Please go ahead.
Thank you, Mr. Lilly. I had my hand up prior to Mr. Serrano's testimony.
I'm sorry if I didn't see it. I apologize.
Okay.
Go ahead.
I wanted to refer back to my Bilecki 13 and Ms. Grady's objection. That letter specifically refers to water rights issues in multiple paragraphs, and also includes reference to a May 20, 2016 requested clarification of Nestle's basis of right by the USFS Forest Supervisor Jody Neuren. And it's incorrect to state that that's a public trust related letter.
Okay, and Mr. Bilecki, I admitted the exhibit into evidence, and I said that to the extent it contains relevant information, I will consider it. So I think I've covered your concern and have proceeded in a way that's appropriate based on your concern.
Thank you. May I ask one other question, please?
Yes, please go ahead.
I'm unclear about the rebuttal process and what that will encompass when it comes into play.
Okay. And the answer is that the hearing notice does talk about rebuttal evidence in some detail. I know the hearing notice is long, but just a minute, let me see if I can find that. And if you don't have it, that's fine, but I'll just tell you what page to look for. This is our November 17, 2021 hearing notice. And it starts, there's a paragraph labeled little c, that's the second paragraph on page 21. of that notice. And this notice is both in the AHO FTP folder and also on the AHO webpage. But it basically, I'll just read it to you because it's only 2 paragraphs long. I'll read it to everybody. It says, after all parties have presented their cases in chief and their witnesses have been cross-examined, the hearing officer will allow parties to present rebuttal evidence. So again, this will be after Story of Stuff Project, Mr. Lowe and Ms. Fry have presented their cases in chief. Rebuttal evidence is new evidence used to rebut evidence another party has presented in its case in chief. And this is important. You don't get a chance to start over. It really has to be responding to evidence that some other party has submitted during this hearing in their case in chief. The next paragraph states, all parties shall submit any written proposed rebuttal testimony and rebuttal exhibits by the deadline specified in this notice. And I've advised everyone that I'm going to change that deadline because this direct part of the hearing is taking longer than anticipated. I'll keep reading. Any written proposed rebuttal testimony shall specify the previously submitted testimony that is being rebutted. This is very important. You can't just, not just you, but no party may just submit something and say, hey, I just want you to consider this. You have to, each party has to say, I'm submitting this rebuttal in response to the following testimony or exhibit that was presented by another party during that party's case in chief. And then it says cross-examination of witnesses offering rebuttal evidence normally will be limited to the scope of the rebuttal evidence. So it's a similar process to what we've done for submitting written proposed testimony and exhibits for the first round, except this time it very clearly, each piece of rebuttal has to state what prior evidence submitted in the hearing is being rebutted. So I hope that gives some clarification. Is that helpful, Mr. Bielecki? I hope it is.
Yes, thank you very much. It's extremely helpful.
Okay, and then, again, it's only 2 paragraphs, but they're very important. So if you can, go check that on page 21 of the hearing notice. All right, so Mr. Lowe, your hand is up. Please go ahead.
Yes, I'm trying to understand so I don't make mistakes. I initially submitted by the 17th of December, my proposed case, what I wanted to talk about. So,
sorry, excuse me. We are treating the declaration you submitted on December 17 as your written proposed testimony.
Okay, so now I get another shot to summarize that, right? And
that's right.
And I can, though, do more than just a 5-minute summary. Don't I have like 45 minutes to summarize?
You will have 45 minutes to summarize, but I just want to make it clear, a summary means a summary of what's in the written statement. You can't start talking about subjects that are not in the written statement.
Exactly, yeah, I realize. So, okay, I think I understand then. I think I can do this
I'm
right.
sorry. You glitched out. You said you can't start talking about subjects that are not in.
Oh, I'm sorry, Ms. Dias. I got a little far away from my microphone. So I just wanted, what I said was Mr. Lowe may summarize his written proposed testimony, but may not cover topics that are not in his written proposed testimony. And I think, Mr. Lowe, you understand that. You're nodding your head yes now, so I assume you do.
I got it. Thank you.
Okay,
Thank you.
anything else on any other questions for now? Good. You got to see if you can take down your electronic hand, Mr. Lowe. All right, thank you. All right, Ms. Grady, you have your hand up. Go ahead, your electronic hand. Go ahead.
Thank you. I just wanted to follow up on a couple of the decisions we were waiting for on you, just to make sure we have a clear understanding of what is coming.
Right. I know that I am still working on a decision on the prosecution team's motion to quash. Is there anything else that you are waiting on from me?
I believe you said you were going to circulate a written decision on the second motion in limine that we submitted this morning, you had given an oral presentation that I think you said you intended to circulate.
Yes, I did say that, and I will.
Are you also going to submit or issue a written decision on the first motion in limine?
I don't think so. I think I'll just leave what I stated in the record on that.
Okay, and then I'm going to, oh, there was one other thing, I believe. You said yesterday that you intended to submit a writing summarizing the ex parte communication with the current owners of the hotel facility.
Oh, that's right. As part of the site visit, what I said I would do and I plan to do, if I can ever get to it, which I hope I will be able to today, is I'm going to send a letter to the tribe, that this is the San Manuel Band of Mission Indians tribe, to the 4 people I talked to yesterday, that will summarize my communications with them. And they had some follow-up questions, primarily about what stops we wanted to do on the site visit. So I will also answer those questions. And they also wanted to know who would be attending the site visit. So I intend to list that as well. At least I will state that the parties on the service list all may attend. And I'll say that there potentially could be 1 or 2 other representatives of the parties who may want to attend. And if we have a date and we can make arrangements, I will notify them of who else wants to attend. I think those were the main things that will go in the letter, but I will be sending a letter. Of course, when I send it to them, I will send it to everyone on the service list. Yeah, just the way I did with the last letter I sent to them.
Thank
All
you.
right, so any other questions? All right. Good. So Mr. Lowe, your hand went back up. Go ahead.
Okay, I just remembered I forgot to ask you. So I submitted my proposed testimony on the 17th. Then I'm going to get another shot. I want to combine my opening statement with my new testimony. Does everything I say have to be written down and submitted before I say it?
All right, so let's be, yeah, this is a little confusing, Mr. Lowe. Normally we have parties present an opening statement, which is where they summarize what they are going to testify to, and then they can summarize the actual testimony. But in your case, since you are the party, it probably makes sense to do that. So I think the best thing for you will be to just take the oath and then provide a summary of your written statement rather than do something separate that's an opening statement.
Okay, a summary of my written statement that I already submitted, or do I submit a new written statement for what I want to say in my 45 minutes?
No, you are not allowed to submit anything new in writing. You will be allowed to summarize what you previously submitted in writing.
Okay, and I need to stay on topic and not get off of what that was.
That is correct.
Okay, thank you. So I don't need to submit anything in writing before I give my case.
Before you summarize what you previously submitted. That is correct.
Okay, thank you very much.
All right, and Ms. Fry, your hand is up. Go ahead.
I just had a thought on that site visit with the San Manuel tribe. You know, there's that Indian Springs, although that term would probably be offensive, but we do have the legal description. Since that's been mentioned, we might want to think about visiting that site. I've never been able to because it's easiest access through their property, but I just wanted to suggest that for something to think about on that site visit. But
does anybody know how you can get up there? I mean, it looks like it's from the map, and I've certainly never been out there. It looks like it's a few miles. Does anybody know whether there's a road or whether that's a trail or how one would get up there? Mr. Lowe, do you know?
There's a good trail up Coldwater Canyon for at least a mile or so. You can see big 4-inch white pipe going a mile or so up there. So I think you can get a long ways up there on their maintenance trail, I would imagine.
And what about the Indian Springs Canyon?
Indian Springs Canyon is, from what I know about it, it's right accessible from the the front there. I'm not sure. Larry knows more about that. I think Mr. Lawrence knows more about that than I do. I think I'm not sure if anybody really knows that much about that. Do you, Amanda?
All right, Ms. Fry, do you know? Can you shed any light on that?
No, I've never been able to get up there, so
Right,
I've wanted to see it. I don't
All right,
know.
Mr. Lawrence, do you know
Yeah.
anything about what it takes to get up Indian Springs Canyon to the springs?
Yes, Mr. Lilly, there is no trail to Indian Springs anymore. It's up a very narrow channel. You have to hike up the channel to get to it. There's no trail.
Okay, well, that might be fun, but I don't think I really want to lead 20 or 25 people up that. I think just from a feasibility point of view, we're going to have to pass on that one. All right, I will see. And, of course, we do have to be very sensitive to the tribe's concerns. They treat these as sacred lands, and I'm not lecturing, but we do obviously want to respect that and need to respect that. And they may put some limitations on where we can go for that reason. I mean, they may decide they don't want to let us on at all, which apparently is their right. So we will see. And I'll just say, when we started out this process, I had not realized, I didn't even know that the tribe owned the land. So obviously I've had to learn a lot. And it seems pretty clear that while BlueTriton may have a right of access to operate its facilities, that right of access pretty clearly does not include the right to bring 20 visitors with them while they're accessing their sites. And I wouldn't ask them to do that because that would not be respectful of the tribe's interests. So we'll see what happens on that and whether or not we do that part of the site visit. That's for the afternoon of the second day. So if we can't do it, we'll terminate early. So, all right. Well, if I don't see any of you sooner by video, we will all plan to congregate at Barclay Plumbing parking lot on the morning of the January 26th. And I will send out a schedule and itinerary for that. And before we wrap up, Mr. Petrozelli, your hand is now up. Please go ahead.
Yes, Mr. Lilly. I just went on the FTP site to check to download the Zoom transcripts from yesterday. It looks like the date for those transcripts was listed as today, the 14th.
Okay.
So
we're trying to keep everything in order, but I will advise Ms. Blanc of my office, who has been doing that, and we'll try to make sure that we have the correct date. Thank you for letting us know.
Thank you.
And if something like that comes up in the future, I know it's a little cumbersome, but the best way is just send us an email with copies to everyone on the service list. I mean, it's pretty mundane, but that way there's no question about ex parte contacts. And we certainly would appreciate any notices of things we need to do to correct our administrative record. I think I know my staff does an excellent job, but it's a lot of material here. So sometimes we need to a few alerts when we need to make corrections. So thank you, Mr. Petrozelli. All right, anybody else for today? All right, well, thank you very much. We'll finish in 4.5 days of our 5 days allotted, but with the understanding I will be coming back on January 31st to proceed with the cases as I've mentioned. So I do appreciate all the attention and the professional attitudes and demeanors that everybody has given during this hearing. I know these are contentious issues that people all have strong feelings about, and I appreciate the way everybody's behaved. And I was just about to sign off, but now Mr. Donlan's hand is up. Mr. Donlan, please go ahead.
Well, I lifted my electronic hand for Mr. Lawrence, who I think has something to provide.
Oh, I'm sorry, Mr. Lawrence. I'm trying to look at 25 tiles, but go ahead, Mr. Lawrence.
Yeah, my electronic hand seems to be off my screen for some reason right now, but thank you, Mr. Lilly. I just wanted to get a clear understanding of any communication ahead of the site visit. How would you like to handle any communication ahead of the site visit?
Okay, and by far the best way to do that is just send an email to the AHO email inbox. My staff monitors that pretty constantly. And of course, just send copies to everyone on the service list. And we do have email. It seems to work pretty well to do fairly detailed communications, and yet then everybody knows what's going on. And If we absolutely have to, we'll set up a conference call if there are things we have to hash out regarding the site visit. But I'm hoping we've got it all figured out. And I certainly do appreciate the cooperation and assistance you've provided and BlueTriton has provided, Mr. Lawrence, particularly for the helicopter part of the site visit.
Absolutely. Thank you, Mr. Lilly.
All right. I'm just going to do one last check here. I'm not seeing any more hands. Everybody, we all have a little work to do between now and the site visit and now the next hearing day. So everybody do the work you need to do, but have a good weekend and we'll be in touch. Thank you all very much. Goodbye.
Thank you.
Thank you.